Well, since John Roberts became Chief Justice, court watchers say it has become strongly pro-business. The court has made a series of decisions on class action lawsuits, employee rights, and discrimination cases that have favored the employer. Michael Maroko is a partner with the law firm Allred, Maroko & Goldberg. He represents employees, and he joins us now by Skype. Good afternoon, Michael.
Good afternoon. How are you?
Why don't you take us through a little bit about what the court has said this week about workplace harassment and how, if you think, that changes the rules?
Well, the court issued two opinions that restricted or narrowed the ability of the average employee to sue for both racial and sexual harassment and a hostile work environment. What the court did was, on the first case, the Vance case, it narrowed the definition of a supervisor and define supervisor as someone who has the ability to hire, fire, or make tangible employment decisions. Which was a very narrowing of the prior definition, which was supervisor was defined as somebody who can just direct someone's actions. The effect of that means is that the average person who's basically controlled by a foreman or a lead person who he or she considers to be their supervisor, previously, if that lead person, foreperson, somebody with authority who can direct them to go there, come here, write them up, discriminated against them, called them names, sexually harassed them, made derogatory remarks about their race. The company, in the prior law, the company was strictly liable for that under Title VII.
Michael, let me ask you though, has the critics of these lawsuits have said that there have been too many class action employee lawsuits, that employers don't know where the rules are, and that there is too much in litigation here that ultimately costs consumers. Do you not buy that argument?
No, I don't. I think that it's only because we've had Title VII for the past 40 years interpreted and expanded the way it was and has been, that we've got the increase in number of racial minorities, women, and other minority groups in the workplace. The restriction of these rights in business that the Supreme Court apparently is on a mission to do is only going to shield business from threats of lawsuits and thereby allow them to go back to their old practices of discrimination.
So what is your advice then for employees on these situations? Because, we hear more about blockbuster cases these days, but workplace cases often impact more people.
Well, the advice is, even though the Supreme Court did not take away those absolute rights, it just narrowed the liability of the employer for being responsible for the consequences of discrimination. But the Supreme Court specifically ratified and acknowledged, and the law is clear, that if an employee faces a situation where he or she believes that they've been discriminated against, they should first immediately go to their human resources department and preferably in writing, but it doesn't have to be, set forth who's doing what discrimination they're facing. And at that point, the Supreme Court has affirmed this, even yesterday. The company has an obligation to conduct an investigation, and if, in fact, they continue to employ a person of supervision or authority in that capacity, and then the discrimination continues, then the company will be liable.
Okay.
The employer has to take
certain actions.
Initially, yes.
Okay, so they narrowed it, but there's still room here. Michael, thank you so much. Michael Maroko, a partner with the law firm Allred, Maroko & Goldberg. We'll have you back on to talk more about corporate hiring news at some point in the future. Thank you.
Thank you very much.